This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together.
I'd like to welcome you today to our spring 2021 Virtual HOA Condominium Academy. Well, first, let's just do some introductory remarks. My name is Beth Mulcahy, and I'm the managing partner of the Mulcahy Law Firm in Phoenix, Arizona. I have enjoyed representing HOAs and condominiums in the state of Arizona for 24 years. And our firm currently represents over 1,000 community associations throughout the state of Arizona. I also currently serve on my board of directors for my association, and I have done that on and off for over a decade as well. So I have a unique perspective as a board member also for an association. Well, first, I'd just like to say thank you so much for the different neighborhood services from all over Arizona, helping our firm put together the spring 2021 Virtual HOA Condo Academy. We couldn't have done this without their support and without their encouragement to provide this free education for board members, managers, and owners and associations. So I'd like to give a special shout out, thank you to the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, Tempe, who have helped us organize this special virtual HOA and Condo Academy. And truly, together we are better. We've come together to put together this wonderful programming for all of you. In years past, prior to the pandemic, as you know, we were able to have classes in person in many of these cities. And putting together the Virtual HOA Academy was a first time for all of us, and it's been really successful. We've had over 100 people in attendance in the prior Virtual HOA Academies. And we have had over 500 views, usually of each class that we teach after the class. So there's definitely a need for these classes, and we hope to continue doing them in the future as well. First, most important thing I want to say to everybody is happy St. Patrick's Day. I am from Irish descent. My great-grandmother came to the United States from Ireland, and I have a lot of wonderful memories of St. Patrick's Day growing up. Where we had a huge family party with Mulcahy's, and my mom also was Irish through her family. And my grandfather enjoyed St. Patrick's Day so much that as part of one of his dying wishes was that we would all get together every year on St. Patrick's Day and have a big party with our family, which we still continue to do even to this day. It may have to be virtual this year. But anyways, that's really looking forward to tomorrow. And I hope all of you have a wonderful St. Patrick's Day and a green beer if you can find one, and some corned beef and cabbage. Okay, so one thing I want to start out with is what we're going to be talking about today. We're going to give a quick little overview of some important hot topics that are going on in Arizona right now that I think you need to be aware of. New legislation, COVID update, a little bit of information on Prop 208 and how that's affecting associations. But the main part of our class today is going to be discussing the ABCs of enforcement for HOAs and condominiums. And so we're going to show you how to handle these violations, owners that are making architectural changes or parking in violation of your documents, leaving their trash cans out, how you can get these owners to comply through fines, lawsuits, demand letters. We're just really going to dissect this issue to help you as you navigate these issues in your association. Okay, we're going to start out today with a poll because I miss seeing all of you in person, and it's important that I know who's here today. I know we have over 100 people, which is awesome. Okay, so it looks like we've got our poll results in. We have 62% of you here today are on a board of directors for your association. 5% are community managers. 22% are interested homeowners, and 11% are other. Interestingly, if we look at the statistics on who's here today, we have 13% from Chandler, 4% from Glendale, 6% from Goodyear, 13% from Phoenix, 6% from Peoria, 29% from Scottsdale, 1% from Surprise, 6% from Tempe, and then 21% are from other. They chose not to respond on that. So great turnout today. We'll know after this class today which cities we need to maybe beef up our marketing on so that we make sure that they're aware of these classes. Okay, let's move right into kind of the hot topics in Arizona right now. The first hot topic I want to talk about is the Arizona Legislature. As you know, our legislature in Arizona is in session right now. It started session on January 11th, 2021. Our firm posts a weekly legislative update on our website, which can be easily accessed through our homepage. So you just go to mulcahylawfirm.com. And every week we put a summary of the new legislation, that and how it's moving through the legislature, any changes to the language on the legislation. And so if you're interested in that, please be sure to check out our webpage. We also are sharing right now with everybody our publication that we just put out this week on the 2021 summary of pending Arizona legislation. So what are some things to think about for this year's legislature? As you may remember, in 2020, due to the pandemic, we had no new legislation pertaining to associations, which, trust me, is a good thing. This year, we're noticing there are fewer bills that we're monitoring pertaining to HOAs and condos. Some thoughts on the legislature this year. They've got their hands full with COVID, with hot topic issues such as elections and different issues that are pertaining to our state right now with civil unrest. They also have, of course, as always, the budget for the next fiscal year is a very hot topic. So there aren't that many bills pertaining to associations that look like they're really going to move. But the ones that they have, some of them are kind of doozies. So I think we should talk about them because some of them are new. We've never heard of this before, likely a sign of the times. So the first one is House Bill 2030, and this deals with first responder flags. This would just add a first responder flag to the category of flags that can be flown within a planned community or a condominium. I don't think that's a controversial bill at all. The next one is House Bill 2052. This one's more controversial. CAI, the local chapter of CAI, put out an alert on this bill recently. And a lot of people are watching it because it's kind of unclear what the intent of the legislature was on this bill. So basically, this bill deals with political and community activity, and it would prevent an association from prohibiting or unreasonably restricting a unit owner's ability to peacefully assemble and use private or common elements if done in compliance with reasonable restrictions for use of the property adopted by the board of directors. So we're starting to see kind of a sign of the times where you can have peaceful assemblies in your association on private areas or common elements, common areas. This is something that we definitely did not ever envision coming, this year. And basically, we'll just have to kind of see where this goes. The good thing is that it appears that the association will be able to pass rules regarding, possibly how many people are attending these peaceful assemblies and where they can be located within the community. So definitely one to watch this year. House Bill 2170 it deals with garnishments and the ability of associations to collect their attorney's fees when they're filing a garnishment. That's a good bill for associations. We're in favor of that. Senate Bill 1379 is talking about vacation rentals, short-term rentals, enforcement. If you had asked me in 2020 what I thought would be the most likely bills that would pass last year, it definitely would have been a correction on the short-term rentals and giving associations better direction in terms of, can they regulate short-term rentals? Are we going to switch it back to cities, towns, municipalities? And so basically, this is an expected bill. And this bill would allow a city or town to impose a civil penalty against an owner for every 30 days the owner fails to provide contact information. So basically, they're just trying to, get contact information for owners who are using their property as a, vacation rental. Another aspect of this bill is that a city or town may require the owner of a vacation rental or short-term rental to maintain liability insurance. And so we're really keeping an eye on the short-term rental things this year. It's possible, maybe not likely, but it's possible that there will be further direction from the legislature on, short-term rentals and whether or not a city, town, or municipality can, regulate short-term rentals through zoning or ordinances. So we're watching that very carefully. The last one deals with political signs. Again, a sign of the times bill. This bill would extend the time a sign could be left up to 15 days after the general election if the sign is for a candidate in a primary election who does not advance to the general election 15 days after the primary election. So again, kind of really interesting how, the legislature is reactive to what's going on in our country right now. We're dealing with peaceful assembly, political signs, and then the issue of short-term rentals, which has been, a topic of discussion for associations now for a couple of years since the law changed and took away the ability of cities, towns, and municipalities to regulate short-term rentals. So we'll have to see what happens this year. We're closely monitoring the bills. As soon as the final bills are, determined and the governor signed everything that the governor has chosen to sign for this legislative session, we'll be providing you with a final summary of all the bills that pertain to associations. So make sure you're checking out our website at mulcahylawfirm.com. And once the legislative session is over, we will have the final bills that are passed for that year. Okay, let's do a quick update on COVID-19. Gosh, it's about a year now, right? Where everything in our lives changed. Specifically, we started doing Facebook Lives to inform board members, owners, and managers about COVID-19 issues and how they were impacting associations. It's been kind of a slow year, but it's kind of been a fast year too, in terms of lots of thinking done on the part of our firm, looking for ways to help our clients and help our industry navigate these difficult times. So it's really hard to believe that last Thursday was 1 year since Governor Ducey issued the emergency declaration regarding the pandemic. One of the great positives of this past year has seen how I've seen many associations and our law firm and my law firm team be able to adjust and pivot and think outside the box and change how we've always done things to, new methods and new ways to communicate. So that's great. We've had a good year of teamwork and working together and caring attitudes in associations, which is really nice to see. Arizona has definitely seen relatively lower case rates in the last week, and health officials are now reporting a drop in hospitalizations. As you know, vaccinations in Arizona started the week of December 14th, and the rollout has moved rather slowly because of a limited vaccine supply around the nation due to a number of different reasons, the bad storms in Texas and now in Colorado. Governor Ducey says he plans to meet the U.S. goal of making the vaccine eligible for everyone 16 and older, as of May 1st. So we're continuing to see the vaccine rollout. Kind of the big news since I was last on Facebook Live and Zoom with you with our first HOA Academy, our second HOA Academy class. This is our third, is that the new executive order was issued by Governor Ducey, as some of you may know, and this included reopening gyms and kind of reopening Arizona in general. So as of March 1st, 2021, the percentage capacity limit that was previously in place regarding various businesses has now been lifted. And so my team is going to share with you that executive order from Governor Ducey so that you have it at your fingertips. We'll have it on Zoom and also on Facebook Live if you want to take a closer look at. Just some friendly reminders, even though the governor appears to be reopening Arizona, associations are still reminded to implement, use, and follow policies based on guidance from the CDC, U.S. Department of Labor, Occupational Safe and Health Administration, and the Arizona Department of Health Services to limit the potential spread of COVID-19. And don't forget that social distancing and mask protocols remain in place. Kind of an interesting thing. I get a lot of emails from associations, and I received an interesting one late yesterday from an association where they were starting to reopen. This is a large master plan community in West Phoenix, and they're starting to reopen, their community clubhouse, and they actually were going to be having, different meetings in the clubhouse, but they were definitely indicating that social distancing and mask protocols and taking people's temperatures as they entered the building were going to be protocols that were going to be in place for quite some time. One question that I've received from a lot of associations is, okay, what about pools? So Governor Ducey, didn't specifically address pools in his March 5th reopening executive order. So we thought for sure that he was going to clarify this shortly after the March 5th executive order. He hasn't. And so something to keep in mind is that there's another executive order that he hasn't claimed is void regarding pools. And basically, what it says is that you shouldn't have gatherings of more than 10 at the pool. And so I think, this doesn't make sense that this executive order, the other one, is still out there since water parks have been given permission to reopen. But until the governor provides further clarification and direction on this, we still think it's best for associations to encourage residents that are meeting at your pool to not gather in groups in excess of 10. It's probably just a dotting the I, crossing the T type of thing. But technically, it hasn't changed, until he withdraws that executive order. That probably will be done when he issues his next executive order in the future. Our team has some great cheat sheets on COVID-19 and reopening the common areas and HOAs and condominiums. We also have a great cheat sheet on running virtual meetings. Just a quick note on virtual meetings. I'm getting a lot of questions now from associations. Can we go back to meeting in person? And is it a good idea? And so just as a clarification point, just be careful because, we're going to be doing a poll here in a minute on the vaccines and whether or not you've been vaccinated and whether or not you think an association should require vaccination to enter the common areas. I think this is a time of caution for associations. Using Zoom or any other virtual platform that you've been using to have your regular board meetings and your annual meetings is really the safest thing to do right now. Of course, if you want to have an in-person meeting, all directives from the governor's order would, indicate that you are able to do that. Just be mindful of social distancing, require mask wearing, and have somebody taking temperatures if they are entering the meeting. In addition, you should have, some sort of a sign indicating that you're entering at your own risk. One creative thing that you might want to do is if you do start having in-person meetings again for your community, put a limit on the number of people that can attend based upon the space that you have available, or do it outside. Okay, next up, the stimulus checks. So I'm sure many of you saw the news over the weekend that many Americans, will soon be receiving stimulus checks. Some people have already started receiving them over this past weekend. And the government will continue to disperse payments of $1,400 to many Americans throughout the next several weeks. This is just a really good time as a reminder to reach out to members in your association regarding any past due balances that have not yet been turned over to the association's attorney for collections. People may have some extra money in their pockets due to the stimulus checks, and it would be a great time for boards to get these owners to clear up any past due assessments or any other charges that are owed to the association. As for files that are with an attorney for collections, we've learned that the stimulus check is garnishable income. And so my firm is closely reviewing collection files right now, taking into consideration the possibility of moving forward with bank garnishments against anybody that we have judgments against, because that $1,400 is in the bank here for many Americans, and it's a good opportunity for the associations to try to collect the amounts that are past due. Okay, we're going to do 2 quick polls, and then we're going to get into a couple of different other subjects, the topic of the day, which is enforcement. So the first poll question is, have you been vaccinated? So the question is yes or no, or I'd prefer not to say. And then the second question is, how do you feel about an association requiring vaccination proof to enter common areas, such as like the gym, clubhouse, pool? And the answers on that are no way, agree, good idea, or unsure. Okay, so our poll results are in. So 61% of you have been vaccinated. That's awesome. 31% say no, and 8% prefer not to say. So interesting that we have such a high percentage of people already vaccinated who are on this call today. The second question is, how do you feel about an association requiring vaccination proof to enter common areas? So 40% of you said, no way, bad idea. 28% said good idea, and 32% said unsure. Interestingly, I was interviewed about 2 weeks ago for a national publication, and we were talking about, can associations require it? And my comment was, I think it could be considered overstepping. The only way that you would potentially be able to require it, and I'm not advising this, frankly, would be to amend your CC&Rs to make it a requirement. Some associations are saying, well, we could just pass a rule because we can make rules regarding the common areas. It's possible, but I think we have to weigh invasion of privacy and, people's personal choices during this difficult time in our country. And I don't really want one of my associations to be the test case that goes all the way up to the Arizona Supreme Court or the United States Supreme Court on this issue, because that would be really expensive. Okay, so let's move right on along to another question that we've received is, do Hipaa laws apply to community associations? So it's my opinion that Hipaa laws do not apply to community associations. This kind of came up a little bit, kind of in a related way when we were asked if we could, associations were asked if, when we put out a notification that somebody had COVID in the community, residents wanted to know who the person was, or is it my neighbor, or have I been exposed to them? And, we were very careful never to give out the name of anybody who, was diagnosed with COVID. And if somebody was directly in contact with them, of course, the association was notifying that a resident, who has tested positive for COVID, it was in the gym or was at the pickleball event on Saturday or whatever. But we never did give out the name unless the owner agreed to it. And we didn't have any. One more thing I want to mention, just that I thought I made a note of this, but I guess maybe I didn't on my notes for today. I just read an article either yesterday or today in the Arizona Republic saying that in the first 10 days of the dispensaries in Arizona selling recreational marijuana, they had $3 million in sales. And so I think we're already starting to see questions from clients of ours asking for our assistance in updating their rules to address smoking of recreational marijuana in the association's common areas or use of recreational marijuana. So if you start to see that become an issue in your association, make sure that you reach out to our firm or reach out to your general counsel law firm to help you craft some rules to help your association as you navigate with the legalization of recreational marijuana. Okay, let's talk a little bit about enforcement. What are the most common violations that we see in associations? So we get contacted on a daily basis by clients, board members, managers, associations, condos, planned communities regarding owners who aren't following the CC&Rs, rules of the association, maybe even the bylaws. So what are the most common violations that we see? So a lot of tenant violations where we have either short-term rental violations or a bad tenant having wild parties, not following the association rules. Another common violation would be not getting architectural approval. So if somebody repaints their house, does a remodel, changes their property in some way, removes all their landscaping, all of those things typically do require approval from the association's board or architectural committee. Not maintaining landscaping, not putting away your trash cans, parking. We hear a ton of questions on parking. How can we enforce it? What's the best way to enforce it? We're going to be talking a lot about this. Smoking is kind of a newer issue, especially in condos. where we have either owners smoking tobacco or possibly even recreational marijuana in their unit in a common area, or maybe even in the common areas of the association, like at the pool or sitting on a bench. Signs, flags. We've had a lot of questions in the past year about controversial signs, whether it was, Black Lives Matter or Trump flags or whatever. All these things have been hot topics this past year. And then last but not least, the one, kind of every association has people that are not paying assessments. If you're lucky enough to be in an association where you have all of your owners paying their assessments, that's great. But what we found is that every association has at least a small percentage of delinquent owners who aren't paying assessments. Okay, so we're going to start out first, just kind of talking a little bit about what's the process. When you have an owner who is not complying with your documents, what's the process that we follow as an association to get the owner to come into compliance? First, I'd like to share with you 2 cheat sheets that our firm has put out. One is called Enforcement of Governing Documents, and the second one is called Levying and Collecting Fines in a Community Association. Both of these documents are amazing resources for you as you navigate violations in your associations. For those of you who may not be familiar with our firm's cheat sheets, we have about 65 different cheat sheets on basically any topic that can help an association's board, manager, or owner better understand how associations operate, what Arizona law says on associations. And so all of our cheat sheets are on our website at mulcahylawfirm.com. And also we're sharing the ones that are pertinent to today's class in on both platforms, on Zoom and also on Facebook Live. Okay, so what's the first thing you should be doing when you have an owner who has a violation in your association? We suggest that you first start out with a courtesy reminder letter. This is just a friendly way to say, you're in violation of the association's documents. Either the board or the management company mails this letter or posts it on the property. We have some associations that have the management company do door hangers that they place on the front door of the home. If it's a rental, that becomes a little more complicated because the owner may not be living there. But some of them do the door hangers and they send a letter. Most of our clients just send a friendly reminder letter stating that, you're in violation of the section in the documents, giving them a certain period of time to correct the violation. And in most cases, what we find is that when you send the owner a letter, they comply. Most of them comply. Maybe 30% blow it off and don't do anything, but 70% of the owners, want to be good neighbors and they comply. The other 30%, then you have to take the next step, which is going to be sending a more formal violation letter. So if the violation isn't corrected in the time period that is given in the friendly reminder letter, then you up the ante a little bit and do a formal violation letter. And usually the board, the management company, or maybe even the association's attorney sends the formal violation letter. And this is just like its name, it's formal. We start threatening fines. We, under Arizona law, we can levy fines, and we're going to talk about that here in a minute. We give them a time period to respond to the violation if we do find them, and we'll talk about that even more in a second here. There's some language that you have to have in this formal violation letter. So what we recommend is that you indicate, what the violation is, what section in the documents they have violated. And then you also have to put this section in your violation letter. It's specific language that state law requires. And it says you have the option to petition for an administrative hearing on this matter in the Arizona Department of Real Estate pursuant to ARS 32-219901. And basically, it's just a requirement for the formal violation letter. And all this is outlined on our cheat sheet. So if you weren't able to write down specifically what I said, look at our cheat sheet on enforcement of governing documents, and that language is in there. Okay, so let's just kind of do a quick little rewind. So if you have a violation, try to do the friendly reminder letter first. If that doesn't work, then up the ante, move to a formal violation letter. In the formal violation letter, you should indicate what the violation is, what section they're violating, the specific statutory language that is required, talking about they have the right to go to the Department of Real Estate, ask for administrative hearing, which we're going to talk a little bit more about that process in a minute. And then also threaten fines. Now, fines are something we're going to take a minute to talk about because, associations have the right to fine an owner. Basically, how it works is that the fine you give notice of the violation to the owner. Typically, that's going to be in the formal violation letter. You give the owner the opportunity to be heard, which gives them a chance to either write back an email or a letter or come to a hearing in person or, virtually right now. And then after we hear the response from the owner, then the next step is then we make a decision. Are we going to continue to fine the owner or not? Are we going to, not fine the owner? So when you're doing fines and your formal violation letter needs to set this up to be in compliance with the law. So the fine has to be reasonable. So the fine, has to be consistent with the problem. So let's give an example. Let's say that you have a trash can that's left out. $1,000 fine for a trash can being left out is going to be considered unreasonable. Maybe you start out with like a $25 or $50 fine, and then it continues to progressively get higher for repeat violations of that same trash can violation. Would be a good example. Now, we'd have to give them notice of the violation, an opportunity to be heard. So that first formal violation letter will set all this up. They'll say, here's the violation. If you dispute this fine, if you dispute this violation, then you can contact us by sending an email or a letter or appearing virtually or in person at the next board meeting. And then at the next board meeting, the board makes a determination whether or not you're going to fine the owner or not fine the owner. And really, you should just take a look at the circumstances. Maybe somebody writes a letter back saying, we apologize, we screwed up, it won't happen again, and the board doesn't levy the fine. Maybe the person has been doing the same thing for a year, and the only way to get their attention is to levy the fine. Some important things to note about fines. Again, the fine has to be reasonable. If you're not sure if the amount that you're choosing for the fine is reasonable or not, talk with your manager, talk with your association's attorney. We can give you a good, feedback in terms of, I think that's a little too high, or I think it's a little too low. Kind of like a common problem that we'll see is that, let's say you have somebody parking an RV in your association on the weekends, and that's not allowed. It may be cheaper for the owner to pay the fine to the association, like if your fine's really low, artificially low, like $25, versus having to take the vehicle out to RV World and pay $75 a night. So we want to make the fine large enough that it's going to encourage compliance, but not so large that it's considered unreasonable if a court's looking at this. Okay, so once we, determine whether the fines are going to be added to the account or not, it's really difficult to collect fines. One of the really great things about being a seasoned attorney, and I can't believe I'm calling myself a seasoned attorney, but I've been around for a while now, is that I have been watching legislation created since 1995. And so I know the history on a lot of this, and it's really actually pretty interesting. So way back in the day, a long time ago, we used to be able to record a lien for unpaid fines. Of course, that was taken away many years ago. And now the only way that we can collect a fine, which is another legislative, action that they took that said that associations can only collect fines against an owner if we file a lawsuit against the owner and obtain a judgment. And then we record that judgment with the recorder's office. So the reality here is, back in the 1990s, when I first started practicing law, we could just levy a fine and record a lien on somebody's lot. We could even foreclose the lien, if you can believe that, for a fine. That's not the law anymore. Now the legislature has made it really difficult for us to collect on fines. So, if we levy a fine against an owner, we're going to have to spend money to collect it, spend money in the form of filing a lawsuit. So the reality on fines are, that we can threaten them, right? But if you only have somebody that has $500 in fines, you can threaten them, you can levy them. But if the dollar amount on the fines is less than $1,000, it really doesn't make sense to be filing a lawsuit against the owner, to collect $200 in fines. Why? Because you're going to spend $800 in legal fees getting the judgment. Now, of course, you can do fines as an add-on to an unpaid assessments lawsuit. That's commonly done. But just filing a lawsuit for $200 in fines, is probably not good business judgment. So just recognize that, fines are complicated in that way. Our legislature has put so many restrictions on them that, we have to take the step of actually getting a judgment to collect the fines. Okay, let's talk a little bit about self-help options. So what is self-help? So let's just kind of do a quick review. So when we've got a violation on a property, we can do a courtesy reminder letter. We can do the formal demand letter. We can levy fines against the owner. The next one is self-help. What is self-help? Self-help is something that is going to be in your CC&Rs of your association and possibly in your bylaws, but 99% of the time in your CC&Rs. And it basically allows the association's board to correct a violation on a lot or unit at the owner's cost if the owner fails to correct a violation in a timely manner. So that's what self-help is. It's, getting the job done for them. It has to be in the association's documents. You have to specifically follow the procedures that the documents require. Typically, there's a notice requirement. We sometimes have to post it on the door. And so, it has to be in your documents in order to do it. Make sure you follow the procedure in your documents to a T. And make sure that once you, pay for the cost for whatever needs to be done, whether it's repainting or fixing something, fixing a broken fence, that you're going to then have to typically file a lawsuit against the owner to collect the money that the association spent in fixing whatever the problem is. So, we have to really, when we're looking at self-help, yes, it's great in that, okay, we get it fixed, right? Quick, let's get somebody out there. Let's follow the notice provisions in the documents. Let's get this taken care of so it looks nicer. But then on the back end, there's kind of some problems. Like, now we got to start over and send a letter to the owner saying you owe this money. And if they refuse to pay it, then we have to file a lawsuit to collect on it. So it's a little bit complicated. So we want to think all of that through if we're planning on doing self-help, if it's an expensive fix. Also, one other thing, just a word of caution that I want to mention is that, sometimes you get these owners, I guess I'm going to call them lazy owners, and they see the association coming on and doing a self-help and cleaning up the landscaping. And now they think, oh, cool, I don't have to do landscaping anymore because they'll just come on and do this for me all the time. And so we don't want self-help to be, like a continual thing every month. That's not something that we want to do. We also want to think about, hey, is this person about ready to lose their property at a sheriff's sale or a trustee sale? We may not ever collect that money that we spent in self-help cleaning up their property. So these are all considerations that you should be talking about with your manager and with your attorney as you're deciding whether self-help is a good idea for your association. Just a quick poll question for everybody. Our fifth poll for today, I'd like to hear from you. Do you know if your association's documents authorize the use of self-help by the board? So I'm curious because a lot of times when I teach these classes, people are surprised when it's great because when I see a live audience, I miss the live audience. But when I see a live audience, I can see people shaking their heads or no, yes. And so these polls kind of help me understand whether or not your association has this type of thing. So 37% of your associations say you have self-help, 17% say no, 47% say not sure. So for the 48 people, 47% that aren't sure, that might be something, a little homework for you. Look at your CC&Rs and see if you have the right to do self-help, because it might be a way for you to clean up some violations in your association quickly. Okay, just a quick word on policies. So it's a good idea for associations to have a policy in place. The board has a policy in place as to how we're going to handle violations so that If you're self-managed, that everybody's clear, this is how we're going to move forward with violations, or if you have a management company, that you're giving them clear directions so that they can just move forward quickly on violations. And your board can just vote on this at a regular board meeting, open board meeting, and basically it will just set up the timeline. So this is how we're handling violations in our association. Courtesy reminder letter goes out. How often inspections are done, I think is really important that you communicate that to your manager and make sure that they're doing that. Check your contract with the management company to see how often they're required to do that, and then make sure that they're actually doing it. And then having these policies in place so that you don't get so far behind on violations. Because I go to a lot of board meetings, and something that I hear sometimes from boards are, we haven't done any violations, in 6 months or 9 months. And think about all the different things that have, gone by during that time that haven't been corrected. Then it becomes kind of an avalanche of problems to try to fix it. So having a policy in place so that everybody is communicating and on the same page, this is how we handle our violations, is a really great idea. And also maybe setting up a fine policy if that's something your association wants to do. You're not required under Arizona law to do that. The state statute gives you the authority to fine. But if you want to put together some parameters on that, that could be helpful. Okay, what do we do now in our phasing that we're talking about on dealing with the violations? So we've sent the courtesy reminder letter, didn't work. We sent the formal violation letter, didn't work, let's say. We find the owner doesn't change anything. Maybe self-help isn't an option. So what are some other things, more legal things that you can do to get the violation corrected? So we have two things that we're going to talk about next, and that's going to be lawsuits and going to the Arizona Department of Real Estate. So let's knock out lawsuits first. So this is going to be for serious violations in your association. So we filed lawsuits previously on behalf of associations to get violations corrected for parking. In some cases where parking, we had a case many, many years ago where we had this limo driver who was parking his limo every night in such a way that the back of the limo was protruding over the sidewalk and into the street. That warranted a lawsuit. We've had lawsuits over unfenced pools, building a guest house without approval of the association's architectural committee or board. So basically, these are going to be violations that are more serious. We're not going to go typically to litigation, file a lawsuit in Superior Court for, just a small little, like having weeds in your lot type of thing. These are going to be either a lot of violations. So as a whole, there's a lot of things that need to be addressed, or one major one. Okay, so what's the 411 on litigation? It costs money, right? There's a lot of costs. If you file a lawsuit in Superior Court, you need to have an attorney. We find that these lawsuits, if they're uncontested, in order to get a court order ordering the person to do what they need to do on their lot, it's usually going to be around $2,000 to $3,000 in legal fees. There's also a lot of court costs. There's filing fees and service of process fees where we have to serve them with the lawsuit. So start to finish, you're looking probably at $4,000 in legal fees. Now, the owner will get a judgment against the owner for those amounts, assuming that the court agrees that they're reasonable. So you can collect it against the owner. The benefit of going to litigation, filing a lawsuit in Superior Court, is the judge orders them to do what they're supposed to do. And we get a judgment for any attorney's fees and costs. And we see these type of judgments issued all the time. So these are, cases that associations should win as long as you're making good choices on the violation that you're pursuing. And it is in fact a clear-cut violation of your documents. But some of the negatives are, okay, so the court orders it. And actually going back to the limousine case that I talked about, in that particular case, the limo driver, he continued to do it even after the court issued an order saying, stop doing this. And the court actually had an order to show cause hearing and ordered that the limo driver, for lack of a better word, come to court to tell the judge why the limo driver was not complying with the court's order. And actually I have great stories, truly. For 24 years of stories dealing with HOAs, I have really some very funny stories, this being right at the top of the list. So I'm at the hearing with the judge, and it's an order to show cause hearing, which is serious, meaning that the judge is mad. This person didn't comply with this order, and the hearing starts. Limo driver's not there. And about 5 minutes into the hearing, and this, mind you, is within the time frame of September 11th. Okay, so security is pretty beefed up at the courthouse. 5 minutes into the hearing, we're showing the judge pictures that the limo driver continues to park his limo, so it's protruding into the street and over the sidewalk. 5 minutes into the hearing, the limo driver comes running into the courtroom, okay, and sits down. And then maybe a minute later, the security at Maricopa County Superior Court comes running into the room, with basically in very agitated form, going to arrest the limo driver. Well, the limo driver had parked his vehicle, his limo, in front of the courthouse in a no parking zone, which is absolutely hilarious because obviously we're there because he was doing the same thing in his association. And so, it was really hard for me to keep my corners of my mouth from turning up smiling just because I'm trying to keep it serious. But how this is unfolding was absolutely hilarious. And basically, once the security guards came into court and explained to the judge that the limo driver had parked in the, loading no parking zone in front of the courthouse and he needed to move the limo right away, the judge told the bailiff to cuff him and put him in jail. So, it's serious. So these are serious matters. So if we file a lawsuit and somebody violates it, there are consequences, would be my point. And the limo was towed. And interestingly, the limo never came back to the association again after that. So, okay, so how is COVID affecting courts? We've seen cases are taking a little bit longer to work through the process, but the courts are definitely in session. The judges are ordering a lot more settlement conferences. They want these cases to settle now more than ever. So if we get involved in litigation, it does take a little bit longer. We're seeing about a 2 to 3 month longer delay on certain things. And also we're seeing judges really push to get cases in front of a settlement conference judge or into some sort of mediation or informal settlement discussions. Okay, let's talk about the other legal thing that you can do if we have a violation of the CC&R. So we talked about lawsuits. The other one is going to the state of Arizona Department of Real Estate. And we're going to be sharing with you right now the website for the Arizona Department of Real Estate. So what types of cases regarding associations does the ADRE hear? So basically, they will hear any dispute between an owner and the association regarding any violation of the association's documents or state law. This is not a forum where management companies can be sued. This is not a forum where construction defect matters can be litigated. This is basically how this works is, and this was set up, I've been watching the legislature for many years, but this was set up as an informal place where associations and owners can resolve disputes. Now, the reality is that associations very rarely use this ADRE to, get compliance for violations. Rather, what we see is that owners who are unhappy with their association go to the ADRE and file a complaint to have their issue heard. So what are the typical things that we see? We see cases on an association didn't increase their assessments the right way. The homeowner thinks that. Or the association isn't giving me records and I'm requesting them. And so basically what happens is that the owner or the association can submit a petition, and all these forms are on the website that we just shared with you. And basically the petition form is right on the website. They have to file a filing fee. Single issue is $500. It's a short form where they just indicate what their beef is, what the problem is. And, basically then what happens is the Department of Real Estate opens a file on it after the filing fee is paid and the form, the paperwork is submitted. and they send it to the other side. And like I said, mainly we're seeing owners using this ADRE to have, disputes addressed. And so the other side gets to file a response, and then they issue a hearing date, usually pretty quickly, like within 90 days of the response being filed. And there's a hearing where an administrative law judge hears the case, basically. And, there aren't going to be any attorney's fees that are awarded. That's by law. They're not allowed to award attorney's fees in this, venue of the ADRE, but they'll hear the issues. And we've had a number of these cases over the years that go to ADRE. Typically, we're defending the association against a claim that's been made by an owner. And one thing that I'd say is that the administrative law judges do a great job. They are very thorough. They understand the issues, and we feel that the rulings have been consistent with the documents and state law. So that's a good thing. And it gives owners a place where they can go and have their issues resolved with only paying like a $500 filing fee for a single issue, or, each additional issue would be $500. So if they have 3 issues, it'd be $1,500. And it gives them a fast, cheap place to have somebody who's independent, an administrative law judge, look at the issue and issue a ruling. One kind of interesting thing is that the administrative law judge can levy a civil penalty, although we don't see that very often. So just interesting for you to be aware of that. And oftentimes, if it's an invalid, like a type of case that doesn't have any merit, or is the type of case that's just meant to harass the association can do a motion to dismiss, and sometimes the judge will just dismiss the case right at the outset. So these are your different remedies that you have as you're, dealing with violations. Don't forget, a courtesy reminder letter, formal violation letter, ability to fine, self-help, going to file a lawsuit, and then the Arizona Department of Real Estate. So I think we've given you a lot of really good tools today that can help you as you, have violations in your association. Now I'd just like to take a couple minutes, just the last few minutes, and talk about what are some specific resources for specific problem violations that we see often. So if you're having issues with rentals, we have a great cheat sheet on how to effectively work with rental properties. The most important thing I want to remind you on if you have a bad renter, the best advice I can give you is make it hurt in the pocketbook for the landlord. The minute that you can escalate this to the landlord with fines and attorney's involvement through a formal violation letter, the faster the issue will be resolved. Okay, parking problems. If you have parking problems in your association, check your documents. Okay, see what they say about parking. Most common parking issues we see are overnight on-street parking, RVs, campers, commercial vehicles, boats, and trailers. Check your documents to see specifically what it says about those items. If you need help interpreting what your documents say, make sure you reach out to your legal counsel or to our law firm to help you with that. Who can enforce the documents on this? It's the board, the association. And so, you can use all the enforcement strategies that we've talked throughout this seminar. And how to enforce it, some things that I didn't talk about that would be add-ons to, the violation letter, the fines, et cetera, lawsuit, would be towing. Again, if you want to tow a vehicle, it has to be in your CC&Rs. Putting those nasty sticky stickers on the driver window for violations, using a boot to keep the vehicle in place. Before you do any of those things, make sure you're checking with your legal counsel to make sure that you have the legal authority to do that in your documents. Okay, next, just kind of quick little subject that we see a lot on violations is refusal of owners to pay assessments. We have a great cheat sheet on this called Our Firm's Secrets to Effective Collection of Delinquent Assessments and Available Legal Remedies. We're going to be sharing those with the Zoom and also on Facebook Live here shortly. There aren't that many associations that have a serious delinquency problem right now. Like, let's go back to 2008 where, things were really starting to tank. and people were not paying their assessments. We're not seeing that right now. We think it's probably because a lot of the stimulus money that's been given in our state and on the federal level, we've kind of always been waiting for the shoe to drop on this since the pandemic started last March. And really, we haven't seen a large uptick in unpaid assessments by owners. But the most important thing is act in a timely manner. If you have an owner who is not paying, you need to be constantly contacting that owner and escalating it up to the attorney as quickly as possible, because the larger you allow that debt to get, the more difficult it's going to be to collect. And so one thing, just a parting thought on this, if any of you are in the audience today and you have an owner who's not paying assessments and you want a free review of the file, we'll do a quick credit eval for you on that owner and let you know what we think is the best way to collect assessments. So all you would need to do is email me at bmulcahy, MULCAHY, at mulcahylawfirm.com, and send us over the information on the owner's name, address, and how much they owe. And, we'll be sure to do a quick credit evaluation for you on that delinquent owner and give you advice as to what we think the next step is to collect on that person. Okay, last but not least, I'm only 1 minute over, which is really good. I'm usually a little bit more than that. So what do you do about owners who make a change to their property without approval? So no architectural approval. Let's say they put in a new garage door, they paint, they change out their windows, they put on a bonus room, they add a wall, they, take out a fence that's always been there, landscape modifications, RV gates, golf cart, concrete pads. We've seen it all. So first, check to make sure that what the owner changed actually violates, or actually required architectural approval, number one. So most of the examples I gave would require architectural approval. Kind of the best way to handle on this is just a little bit different fine tuning from how we would normally handle a violation. So we suggest the friendly violation letter first, and then ask the owner to submit an application. Give them the form with the friendly violation letter, try to work it out, okay? Once they submit the form, if the application is denied, because this is just never something that we would allow, make sure you're talking with your attorney on what's the best way to get the owner to return the property to the original condition. If the application is approved, move on. Tell them in the future, any of these architectural changes need approval. Please do not do an architectural change without getting the written approval of the architectural committee in the future. A common question I get is, does our board have to approve this architectural change that they made without getting permission just because the owner already did it? The answer to that is no, you don't. But it does complicate things. I'm not going to lie to you. I mean, it's complicated when you have somebody who's put out a large cash outlay to, change something and they didn't get approval. Because the scrutiny that will be given by the court, there's a case in Arizona that says that owners should be allowed to have the free use and enjoyment of their property. So we're balancing what the CC&Rs say in terms of architectural approval, which frankly can be, something that could be open to interpretation versus what they did. So if you're in one of those situations where the owner didn't get approval, they spent a bunch of money, and now the board wants to deny it, you definitely want to get your legal counsel involved to give you good advice so that you set it up for success if you do have to file a lawsuit to get them to take it down. Okay, so final parting thoughts on architectural approval. It's the same legal remedies that we talked about, the courtesy violation letter, give them the form, ask them to fill it out, kind of did the analysis of if they submit the form, if you're going to disapprove it, make sure you get legal counsel involved. If you're going to file a lawsuit, really think through how much is this going to cost? Is there another way that we might be able to get the owner to comply? Maybe even going to the ADRE and having the ADRE rule in favor of the association. Okay, so that's the end of our presentation on the ABCs of enforcement. I would just like to thank everybody for being here today and wanting to make your communities better. And I appreciate our partnership with the many different neighborhood services around Arizona who have come together to create these classes. Our fourth class for the spring 2021 Virtual HOA Academy is going to be on Tuesday, April 20th at 11 a.m. And our topic for next month is Board Member Boot Camp. You've been elected to your board. We're going to tell you everything you need to know about your duties and responsibilities serving on your board. And we're also going to give you tips on how to have a successful association and how to get things done. And as always, bring your questions. We always save time at the end to answer every question that's submitted. So just a couple closing remarks. March Madness is starting here soon, so I hope your teams all advance in the bracket as you hope. I also like to wish everybody a very happy St. Patrick's Day. And finally, I just want to thank again the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Scottsdale, Surprise, and Tempe for organizing this virtual HOA Academy. This is our third class in our series of classes. We're planning on having classes throughout 2021 with these different neighborhood services departments, likely still on a virtual platform through 2021. So continue to tune in for the classes. We have lots of great programming that we're planning for the next 9 months. So thanks for being here today, and we look forward to seeing you next month.